I am not obsessed with issues of race, I'm not. In fact, my philosophy has always been, racism is not my problem. Racism is your problem. And so consequently, I'm not going to occupy my headspace dealing with your problem when I should be getting on with my life.
Good evening, ladies and gentlemen. It is my honor and privilege to read the citation for Courtenay Griffiths QC. Courtenay is Joint Head of Chambers of Garden Court Chambers, which is a well-known and highly regarded chambers in the UK. Courtenay graduated from the London School of Economics, London, in 1978, and was called to the bar in 1980. Between 1981 and 1986, he was a legal assistant to the then GLC's Police Committee Support Unit and a Revson Fellow at the City College in New York. He returned to private practice in 1986 and took silk in 1998. He became a recorder of the Crown Court the following year. Courtenay received honorary doctorates from both Leeds Metropolitan University and his hometown university, Coventry. He's a bencher of Gray's Inn and has chaired the Public Affairs Committee of the Bar Council. He has written and lectured extensively on all aspects of the criminal justice system. He has been counsel in some of the most famous trials and inquests in the UK, and outside, of course, including the Damilola Taylor murder trial, the PC Blakelock murder trial, the Brighton bombing, the Harrods bombing, and the Canary Wharf bombing. He also recently acted for the defense in the WPC Nasri murder trial. Courtenay was born in Jamaica, and in 2010 was named the Power List, which profiles Britain's 100 most influential people of African and or Caribbean heritage. He was said to be influential because he has become an internationally renowned barrister, not just a powerful domestic one. Of course, we will all know that he is lead counsel for Charles Taylor, the former president of Liberia, in The Hague, where he's standing trial for charges of crimes against humanity and war crimes. I think, as one headline put it, in the midst of many, many headlines, forget Naomi Campbell, the real star is Courtenay Griffiths.
Thank you, Segun. And can I also take the opportunity to thank Debo for all the hard work and effort she has put in to making this publication such a success over the years. And also a thanks to Freshfields for their hospitality on this and I think previous occasions, and for all the support they've given to this very important publication for us as non-white. I prefer the short and black lawyers. And I also want to thank you for attending. Now, I've always had difficulty with the concept of a Black History Month, because it's almost as if the trials and tribulations we face as non-white people in this country can be tidily packed away for the other 11 months of the year. Because it seems to me the very fact of our otherness gives us a certain consciousness about that fact, which lasts 365 days a year, 12 months a year. We don't need to be reminded in a particular month what it is to survive as non-white people in not only this society, but in the world. Because for my part, within and without the law reflects that schizophrenia, that schizophrenic relationship which I, as a black person, and particularly a black man, have with the concept of law and indeed law and order. Whether in its national or in its international expression, I say that despite being one of Her Majesty's Council, despite being a recorder, despite being the joint head of one of the largest sets of barristers' chambers in the country, very much an establishment figure, I accept that. But nonetheless, I do make that point. Because the fact is, as we all know, and we only have to go to the Home Office's website to reaffirm this, as black people, we're more likely to be victims of crime. We're more likely to be stopped and searched. We're more likely to be arrested, less likely to be cautioned, more likely to plead not guilty, more likely to have our cases against us discontinued, more likely to be acquitted, which speaks volumes, more likely to receive longer custodial sentences. And as we all know, we make up a disproportionate number of those, male and increasingly female, who populate our prisons. And more recently, our presence is disproportionately reflected on the National DNA Database. And when an MP, Mr. McNulty, was asked on BBC television, why was this discrepancy? He blindly replied that that fact merely reflects who comes in contact with the forces of law and order. It's strange that. But why is there this greater contact? And the interesting thing is, if you go to France, if you go to Germany, or any other European state with another substantial population, likewise if you go to the United States of America, the same or a similar picture emerges. And one has to ask, why is that the case? Because in every instance, the fact of that otherness still tends to define our relationship with the law. There is nothing controversial here. I am stating a fact about our national condition. The fact is, characteristics which set you apart from the majority of the population result in you being treated differently by the law. Being another makes a difference. And I want this evening to transplant that recognition out of its national context in order to see to what extent it provides guidelines as to what is happening in our world at an international level. My starting point is this. The behavior of British government since Margaret Thatcher, and especially under the leadership of Tony Blair, suggests that in terms of foreign policy, there is still a hankering after that imperial past. In the colonies of Ireland, the Caribbean, and elsewhere, a minority people with a technological advantage needed to keep the majority in their place, the better to exploit them and their natural resources. Discipline has long been the handmaiden of exploitation. The law, often in its most brutal guise, was part of the thin red line which preserved civilization. The catchword of that old imperialism. It's for your own good. We are bringing you the benefits of civilization. The catchwords for the new imperialism are, we're bringing you democracy. We're getting rid of a tyrant. We're bringing you the benefit of the rule of law and order. We are invading your country, killing your people in their own land, bombing your mosques, torturing those who we hold captive, because we are liberating you from tyranny. we are bringing you the wonderful gift of democracy. It's for your own good. It's called tough love. And for the ignorant, you see, in this war on terror, there is a superficial attractiveness to the assertion, because there are aspects of Islam, its treatment of women, its at times barbaric criminal sanctions, its demand for conformity in worship and thinking, which grate on the consciousness of those anxious to support any opposition to American imperialism. Nonetheless, there is this aspect to their treatment which effectively says we have brought you the rule of law, yet we who bring that law are above it. And we need to understand this. As the Nigerian writer Achebe once said, if a man comes to your land to steal your oil or your minerals, you wouldn't expect him to say, I'm doing it because I'm more powerful than you. I'm doing it because my technology is far in advance of yours. For such a man to make such an admission would brand him as a bully and a tyrant, an exploiter. So what do such men do? They employ individuals to dress up their naked greed in different terms. And so they will tell you, as they did in Iraq, that we're bringing democracy, we're getting rid of this tyrant Saddam Hussein. So the gift of civilization then, the promise of democracy now, they are, to my eyes, code words for Western capitalism in its most exploitative and destructive forms. This is the 21st century equivalent of the 19th century white man's burden. This is what international criminal justice today is about. Now, in July of 2007, I was going through the security check at Heathrow Airport on my way to Jamaica when I received a telephone call from the principal defender of the Special Court for Sierra Leone. Charles Taylor had just sacked his whole legal team. There was a state of panic gripping the court because here was their most high-profile trial, and it looked as if it was coming off the rails on the very first day, the 4th of June, 2007, when the trial was supposed to begin. So I was approached by Vincent Nemeli, the then principal defender, and I thought about it for a while, and then I accepted. It was my first venture into the international arena. I'd never even studied international law at university. I'd never had any kind of contact with international jurisprudence, none whatsoever. But I saw it as a challenge because, frankly, I had spent the previous 15 years doing back-to-back murders at the Old Bailey, for the main part involving black young men killing each other. And I got fed up of that particular treadmill, and this offered an alternative, so I accepted. Now, the Special Court for Sierra Leone was set up jointly by treaty between the United Nations and the Sierra Leonean government. It is funded by voluntary contributions, but the main contributor is the United States of America. Now, that court is mandated to try those who bear, and I quote, the greatest responsibility for serious violations of international humanitarian law. In the territory of Sierra Leone, between the 20th of November 1997, when a peace agreement was signed between the then Sierra Leonean President Ahmed Tejan Kaba and the RUF, the Revolutionary United Front. Now, Taylor faces an indictment which contains 11 counts, covering inter alia, murder, rape, including mass rape, genocide, acts of terror, enslavement, looting and burning, sexual slavery, conscription of children into an armed force, and also attacks on United Nations peacekeepers and humanitarian workers. Those are the charges being brought by the special court, although the allegation of genocide and the attacks on United Nations peacekeepers doesn't directly feature in Taylor's trial. We defend Charles Taylor. I've never denied the fact that atrocities were indeed committed in Sierra Leone. The images of children, women, men, their arms amputated, is an image which I'm sure is deeply embedded in many of our consciousness from that time over a decade ago. And I do accept that such brutal and heinous crimes ought to be brought to justice. And I applaud the good intentions of most of the lawyers and judges involved, one of whom is my own dear friend, Sir Desmond De Silva, Queen's Counsel. But the question which has troubled me throughout my involvement with the Charles Taylor case is this: why has the United States, and other Western countries primarily, decided to fund this exercise in Sierra Leone, when the millions of dollars which could have been spent on repairing the infrastructure of that country, building the roads and the schools that the people really need, why has it decided to expend all of that money on setting up this international criminal court, which has tried 13 individuals since its inception in 2002? I've been asking myself those questions ever since. And in search of the answer, I had to go back to 1998, when the nations of the world agreed to create the International Criminal Court. 60 ratifications were needed to get the ICC off the ground. This was achieved on the 11th of April 2002. That meant that from the 1st of July 2002, any acts of genocide, war crimes, crimes against humanity committed after that date could be tried by the newly established court. In Rome in July 1998, the ICC was given the go-ahead with a vote of 120 to 7. The 7 who voted against were China, Iraq, Israel, Libya, Qatar, Yemen, and guess who? The United States of America. What strange company does the champion of democracy, the champion of law and order worldwide keep? In fact, the United States of America has been the most vocal opponent of the ICC, culminating at the beginning of May 2002, with the Bush administration announcing that it had resolved to unsign the Rome Statute. Now, in a sense, one can understand that. There is a simple reason for this. The USA cannot have its citizens being tried by foreigners, particularly its military personnel. An imperial power cannot exert its power subject to such constraints. We are above the law. We impose it. That is what law and order is about. Put differently, could you imagine a situation where the centurion who executed Jesus Christ could have been put on trial by the Jews? If you're an imperial power, it just can't happen. And if you retain under yourself what you see as your God-given right to intervene anywhere you want in the world, how can you run the risk of your soldiers being arrested and carted off to the Hague? It can't happen. That's the reality of things. And then when we look at the wording of the Rome Statute, we see these words: reaffirming the purpose and principles of the Charter of the United Nations, and in particular that all states shall refrain from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. Now hold on a minute. When the UK signed up to the Rome Treaty, our then Foreign Minister Robin Cook, the late Robin Cook, was interviewed on BBC Newsnight, and his interrogator asked him, "So, Foreign Minister, now that the United Kingdom has signed up to the Rome Treaty, does that mean that Tony Blair or George Bush might be put on trial for their illegal war in Iraq?" This was his answer. "This is not a court set up to try the likes of the Prime Minister of England or the President of the United States of America. What could be plainer? This is a court set up to try those lesser breeds without the law." And who are they? Just pause for a moment and consider this. Since it was set up, the ICC currently have 5 individuals, 2 of whom are undergoing trial, the other 3 are awaiting trial. Guess where they're from? Africa. Every single investigation currently being conducted by the ICC, guess where it is? Africa. Why? Now you see my starting point. My starting point is the way in which the law here has become infected by issues of race. And what we seem to be doing is recreating that same situation at an international level. And it's something which I, as a black man, cannot countenance. I can't countenance that for one instance, particularly when I see lurid photographs from Abu Ghraib finally appearing, particularly when I look at Guantanamo Bay, particularly when I look at drone attacks in Pakistan, where individuals who have not been put on trial, against whom no shred of evidence has been produced, are targeted electronically and killed along with their wife and children without any due process to which this United States of America is so wedded. Because let us break the Charles Taylor case down to its core issue. Taylor is charged as president of a sovereign state, Liberia, with sponsoring and backing a rebel movement in a neighboring country, either in order to control the mineral resources, either, as we suggest, to protect his border because of anti-Taylor forces which were attacking from Sierra Leone. In any event, in so doing, he's protecting his national interest. Now, hold on a minute. Where have I come across anyone on this planet behaving in that way? What happened in Nicaragua? What happened in Afghanistan when the USA created the same Mujahideen through funds and arms and ammunition channeled through the Pakistani intelligence department, a fact which is now something of an embarrassment to them? What happened when that apartheid regime in South Africa intervened in Angola? What happened then? What happened when Israel most recently intervened in Gaza and is using weapons banned by the United Nations? Tell me, what is the distinction between the two? So how is it that one can get hold and change from the African continent at the beginning of the 21st century to stand trial? How many of you honestly believe that Tony Blair or George Bush would ever be put on trial for that illegal war in Iraq? It's never going to happen, and you know it. Everybody knows it, because the bottom line is, and this is the reality of things, power is at the heart of international criminal justice as practiced at this point in time. That's what it's about. Because at the end of the day, ladies and gentlemen, and I'm winding up because I see Debo looking at me through his eyes. When I studied law at the London School of Economics so many years ago, I was led to believe that whether you're a princess or a prostitute, whether you're the president of the United States or the president of Little Liberia, the law is above you. That is not the current case. And I think we, as non-white lawyers, have a very important role to play in how this system of international criminal justice evolves. We have a very important role to play. I don't have to reiterate the fact that all of the defendants currently before the ICC are black. Yes, the ICTY, the Court for the Former Yugoslavia, is still running. The Rwanda Tribunal is still running. We now have the Special Tribunal for the Lebanon, which is scheduled to start whenever that's going to be. But in any event, the fact of the matter is, in whichever of those forums, we as non-white lawyers have a unique historical consciousness which we can bring to such a struggle. Furthermore, the opportunity to engage directly with other legal systems around the world, particularly in Africa, may be one that some of you may find attractive. And the point is, now is the time to get in on this game, to get on the ladder, because the bottom line is, this system is just starting. It's only been running for 10, 15 years or so. And now is the time for us to get involved. And there are major opportunities out there to be taken up by us. And it's also an opportunity to apply the unique skills we have as British trained lawyers in that international arena. That's in The Hague are from here. Because for the most part, many of the lawyers who are coming into those courts are coming from civil jurisdictions where the judge does most of the questioning. And so their skills as cross-examiners is nowhere near ours. This is something we do day in, day out through our professional careers. And they can't match us on that level. And I say that without fear of sounding immodest. It is a fact. And we need to take advantage of that opportunity. Furthermore, in the current climate, when there is a squeeze on legal aid, and let's be frank, most of the work we do is in that area. So who is going to be disproportionately affected by these changes? And here we have another opportunity overseas. To my mind, it's something we have to seize, an opportunity we cannot allow to pass. I'm going to conclude, ladies and gentlemen. What I want to conclude with is this sentiment. I don't want you to misunderstand my position. I am not obsessed with issues of race, I'm not. In fact, my philosophy has always been, racism is not my problem. Racism is your problem. And so consequently, I'm not going to occupy my headspace dealing with your problem when I should be getting on with my life and developing my own abilities. Because one of the things I learned as the only black kid in a private school from age 11 until almost 19 was this. Oftentimes, racism was being used by my white colleagues, not because they believed it, but in order to distract me from my goal, because you spend so much time dealing with it. You don't deal with your real mission in life. So I'm not obsessed with race. I'm not obsessed with race at all. I am rather obsessed with injustice in whatever form, and will continue to oppose it, whether here or in an international arena. and I'd like more of you to join me. Thank you very much.